All right, Ms Murray, now is there more you want to say?
Only in answer to my Lord's question before the luncheon break. Our position is this. If my Lords are with me that there was a failure to consider what, if any, other duties were owed, and maybe even specifically whether there was a decision which had to be made about whether a duty was owed under section 190 to the appellant, then our position is remit, that the decision must be quashed, it is vitiated, and that it must be remitted to the local authority for an entirely new decision on everything. That being my position, I will explain by way of 3 extremely brief submissions. Firstly, if my Lords are with me as to that, then the decision maker misunderstood the duties that were available under the part and misunderstood the obligation on them to make decisions as to which duties were owed under the part, and that's significant. The decision maker having understood so completely, as it were, it would only be fair for an entirely new decision to be made. A different decision maker, benignly approaching the same set of facts, may well reach a completely different conclusion, and the applicant is entitled to have one decision that is as a whole, as it were, because that is her right to a decision under Part 7. Similarly, a decision maker approaching the question of what duty is owed but unable to approach some aspects of her application would have their hands bound in a way that would be, in my submission, impermissible and unhelpful. They should be allowed to approach the decision de novo, as it were. Those are my submissions.
Yes, Ms Murray.
Malay, we did take the opportunity, I should say, to speak over the lunch break, and I took the ability the opportunity to take some further instruction on what the current factual position is. Now, it's not strictly relevant, but it might assist the court to some degree to know what that is. So, what's happened factually is the appellant reapplied to the local authority as homeless, a new homelessness application in October of last year.
Ms Mullin, please slow down because I'm writing.
I'm so sorry, Malay.
All right, the appellant reapplied.
In October of last year. In November of last year, the local authority accepted the relief duty was owed. That was on the basis that she was homeless and in priority need.
And we've got that letter.
Indeed. That's in the supplementary bundle. What's happened since that letter is the local authority on the 20th of January of this year sent what's being described as an informal minded to letter. So it's not a minded to letter under the reviews regulations. It's an extra statutory letter saying what we're likely to do is find you intentionally homeless in our section 184 decision.
That's what they've said, is it?
That's what the local authority has said. It's likely to do that. Those instructing my learned friend have written back within the last few days saying we are not intentionally homeless on the basis that we have had a period of settled accommodation. There's a number of submissions made about the legal rights and wrongs of the minded to letter in the local authority's position, but the central thrust of it is we've had a period of settled accommodation in private rented accommodation, which the local authority was told the appellant has been occupying since February 2022. And that is said to have broken the chain of causality in effect, so that there can be no intentional.
Has she lost it?
No, she remains in it. So she was offered alternative accommodation because the local authority accepts it's not reasonable for her to continue to occupy. Therefore, despite the fact that she has this private accommodation, she's homeless, and offered her alternative accommodation. That was refused on the basis that the appellant would rather stay where they are because the alternative accommodation is likely to be hostel or B&B type accommodation. So she remains in the unsatisfactory private rented accommodation. Now, where does that leave this appeal? It's fair to say, I think the bar in general was unaware of all of that until lunchtime, in terms of what other than that there'd been a new application and that the relief duty had been accepted, which is in the supplementary bundle. But I certainly didn't know about the Minded 2 decision in 20th of January. Where does that leave this appeal? On one view, it doesn't make any difference. The court is seized with an appeal against effectively the review decision from that was the subject of the appeal below. It might make a difference if the court is with my learned friend on what is said to be the height of her case. And as I understood the height of her case to be, that there should have been a decision back in either in 2021 or on one of the subsequent reviews that the appellant was intentionally homeless and was thus owed a short period of accommodation somewhere. Now, if that's right, and I appreciate my learned friend says it has just submitted that what she says should happen is there should be a wholesale quashing of the decision on the review, including all the suitability matters. But if I'm right, that the most that she could really ask for would be a decision that Section 190 applied and that there's a short-term accommodation duty, then that is what she's either got or is likely to get under this new application anyway. If she were to concede that she was in fact homeless intentionally, she would be owed then the 190 duty. There would be a duty to secure accommodation for a short period of time. I'm told it would likely to be between 6 and 8 weeks. Now, the local authority, for its part, if the appellant's opposition to the informal Minded 2 letter that's been sent recently is dropped, the local authority will inevitably make the decision it was minded to make, and it will accept that duty. Now, I say, for all the reasons I say in my skeleton argument, we didn't go that far, my lords, because I say the appeal as a whole is misconceived, and I know my lady, my lordships have my skeleton, but there are a few strands from the oral submissions that I want to pick up, but I'll do my best not to repeat what I say in my skeleton. But the central premise of my opposition to the appeal, and I can tell the court's well seized of it, is that all there has ever been in this case is a request for a review of suitability. And that's exactly what the reviewing officer produced. Yes, in it, he says he makes some comments about duty, but in terms of what he was determining on the review, was the suitability of the property that was offered back in 2021. Now, why is that important? That is important because the jurisdiction that the reviewing officer had, that the county court had on an appeal from his review decision, is in respect of that decision, and specifically the suitability decision, because the framing of Section 202...
Sorry, will you just slightly slow down?
I'm very sorry, my lady. It's my habit, I speed up. I'm so
Well,
sorry.
if it's any consolation, when I was in your position, I used to be told to slow up as well. All right?
You were.
So, what?
You were.
Yes, thank you.
I'm so sorry. I will slow down.
Yes. Well, there you've heard it from two of us. All right, Mr. Mullin.
I'm so sorry. So
That's all right.
Section 202, page 26 of the authorities bundle. And I just invite the court to turn that up briefly. And Section 202, subsection 1 says, an applicant has the right to request a review of, and then there's a list of these various decisions. Now, it is not the case, contrary to my learned friend submission, I say, that whichever gateway you use, that the whole housing application is up for grabs, including duty, including suitability, including any other point of law or fact that the appellant or the applicant at that stage might like to raise. And that's clear from when one looks at subsection 4 over the page on page 27, because it says, on a request duly being made to them, the authority or the authorities concerned shall review their decision. So what they're reviewing is the decision that's identified in one of the gateways. So it is not a reconsideration of the entire relationship between the parties or all of the decisions that have been made on a homeless application, of which there are inevitably many. And then when one moves over to the next relevant statutory provision of...
I think just picking up there.
Yeah.
I hadn't noticed before that all the subparagraphs, or possibly not all the subparagraphs, they're all, the first words are any decision of.
Yes.
So A is any decision of a local authority as to eligibility.
Yes.
B is any decision of the housing authority as to what duty, if any, is owed.
Yes.
And then H, any decision of local housing as to suitability.
Yes, my lord.
Which certainly supports the first half of your submission, that these subparagraphs or subsections are specific.
My lord, yes, and there's, I'm slowing down, there is also authority that there remain matters, and it's touched upon in Ahmed, in the postscript to Ahmed, that there remain matters that are outside of the review framework, about which the administrative court retains a supervisory jurisdiction. So, because there's I think it's probably best described as a practice note at the end of Ahmed that says, where possible, homelessness challenges should be brought via the review and appeal route rather than by way of an application for judicial review. Because in that case, they were both. And they were heard, the appeals from both were heard by the Court of Appeal at the same time. But there was, I think, criticism's probably putting it too highly, but this court said, wherever possible, this is something that could have been and should have been resolved in the review and appeal route rather than on judicial review. But that doesn't. But it acknowledges that there remains a supervisory jurisdiction, the administrative court, for matters that fall outside of these gateways. Now, if my learned friend was right, you request a review under any one of them, and then everything is up for grabs, it would seem to me that must be wrong. That would be an incorrect observation. So, for example, interim accommodation. So the accommodation as this appellant was owed initially, the suitability of that accommodation is only, there's no right to request a review of the suitability of interim accommodation. Where a local authority fails to make a decision at all about something, then there's no right to request a review of it because there's no decision to review. And the appropriate remedy then is to seek a mandatory order from the administrative court that such a decision is made. And I'd respectfully agree with my lordship's characterisation of the gateway starting with any decision as to a particular subject. And then when one moves over the page, over a couple of pages to page 30 in section 204, which creates the jurisdiction of the County Court on Appeal, subsection 1, if an applicant who has requested a review under section 202 is dissatisfied with the decision on the review. So again, my submission is the thread that runs through these provisions is that there has to be a request for a review of a specific decision. Now, of course, a single letter can contain a number of decisions, and again, they frequently do. So an offer letter will contain a decision that the offered property is suitable. It may well also contain a decision that the duty, whichever duty in question, is going to come to an end upon the acceptance or refusal of that offer, a sort of prospective duty decision. Ravichandran recognises that those are reviewable, and I'll come to Ravichandran. But they're two separate review paths. Now, on the facts of this case, I think it's conceded by my learned friend in effect, there has only ever been a request for a review of the suitability of that accommodation.
I was just biting my tongue on that. Not quite, because what she says is that the addition of ground 3 in the skeleton argument, or which we can see in the skeleton argument for the first challenge, demonstrates that duty or scope of duty was in issue.
I accept that there was an argument made in that appeal about duty, but the wording of the statute is quite specific. It's not enough to raise it at some point further down the line. What has to happen is there has to be a request for a review. Nowhere is that, no such request exists, because the request for the review in this case predates the local authority's decision on duty. There is then no subsequent request. All the representations on review say nothing about the decision on duty.
So, for example, after the settled appeal, that would have been an opportunity to add additional grounds or a separate specific request in respect of a review?
It could have been. It would have been, in my submission, a long way out of time by that stage, which is the difficulty, because you only have 21 days to request your review from the decision. Now, the local authority has a discretion to accept an out-of-time review. They frequently exercise that discretion, not as frequently as people would like, but it's far from uncommon, because local authorities are realistic. They recognise that these are legal technical matters, and that people without representation often might not make a point that once they've obtained representation and just ticked over the time limit by a week or a short period of time, wouldn't have been able to make. That's not relevant in this case. So they could have requested an out-of-time review at that stage, absolutely. Now, a failure to conduct a review in time or out of time, is another matter that sits within the jurisdiction of the administrative court if one wants to challenge that decision. So if a local authority irrationally refuses to conduct an out-of-time review, where there are the best possible reasons for it being made out of time, say that, I don't know, the appellant was hospitalised for more than 3 weeks and completely incapable of doing anything, then there is still that supervisory jurisdiction there. But yes. So, but for the reviewing officer to be obliged to conduct a review on duty under section 2021B, there would have had to have been at some point a request for a review. There never was, and there never was.
Saying to have jurisdiction, there has to be a request, or
for the machinery of the Act to be in play. In my submission, yes, because a local authority is at liberty to withdraw its decisions at any stage unilaterally. But for there to be a county court appeal, and indeed an appeal from the county court to this court, and for the courts, either the court below or this court, to exercise its jurisdiction on remedy, there has to be a review decision requested, a review decision produced, and then an appeal. And that's in effect the submission I made to the court below, and that was accepted. That whilst inevitably the review decision is going to comment upon other matters, and the reviewing officer's view that there was no further duty owed, what he doesn't fall into legal error in terms of the jurisdiction on review and on appeal, unless he does something makes some error in respect of suitability, because that's the decision that's the subject of the review, and the decision that's then subject to an appeal. So, my learned friend took the court very helpfully through most, not quite all, but most of the representations that were made on review. So there were two others that weren't directly referred to. but there's the first minded to letter that the court spent some time on. There was a response, that's the 7th of January 22 letter at page 10. There's a response to that letter at page 92. Now, it's incorrectly dated the 17th of January 2021, but one can see from the following paragraph that it's in fact in response to the 2022 minded to letter. Now, my learned friend criticised the reviewing officer for not making this decision about duty in his minded to letter. And in this response to it, and indeed in response to the second minded to letter, it would have been open to those that instruct my learned friend, or I appreciate this was a different firm acting for the appellant at the time, but it would have been open to our legal representatives at the time to say, well, hang on a minute, you're all the points that are being made to this court now.
All the what?
All the points that are being made to this court now. Could have been said, well, we don't accept you've made a 184 decision, and if you have, we wanted a review of it, and why aren't you dealing with it? And the extent to which you do deal with it, we say, is insufficiently reasoned and unclear. Because turning back to that minded to decision on page 11, what the reviewing officer says in the second paragraph at that page is, I must therefore uphold the council's decision given in the decision letter of 24th of September 2021 that the council does not have any further duty toward you. Because I think in submissions, my learned friend had said what was needed, the minimum that was needed was something along the lines of the decision in Ahmed, or the decision that's described in Ahmed. And I'd written down, we considered whether any duties apply, and they don't, was the quote. And in my submission, that is that sentence of the letter, just in a slightly different form of words. It's saying exactly the same thing. There is no other duty the council owes you. Now, it doesn't cite section 184, but there's no requirement, or it doesn't identify itself as being in support of section 184. That's unsurprising, because there's been no request for a review as to duty. But the statement is clear in my submission that the reviewing officer has thought about whether any further duty should be owed and has found that it isn't. Now, an argument from silence is not good enough in these situations, my lords, because it is not for the local authority to demonstrate that it hasn't made an error of law. It's for the appellant to demonstrate that one has been made. And of course, there's the normal public law presumption of regularity in these sorts of decisions, and what my learned friend has already said about the benevolent reading of them. But that is particularly combined with the paragraph at the end of the decision that my learned friend's already taken the court to, paragraph 26, is sufficient in my respectful submission to show that the reviewing officer had considered whether any further duties were owed, including section 190. And I say this in my skeleton, but it bears repeating. It is not the role of the reviewing officer to say, go through every conceivable duty that might be owed, or every conceivable gateway or way that a duty might come to an end, and say, well, this doesn't apply in the circumstances for these reasons, this doesn't apply in the circumstances for these reasons. He is entitled to say, what all the local authority has to do is say what duty, if any, is owed and the reasons for it. And this is in the context of extensive written submissions being made about why the appellant says she refused the offer, and it's all to do with suitability. None of it's to do with any sort of procedural error said to have been made.
So you, or the respondent, on the first county court challenge and on the 2nd could have taken a sort of preemptive strike, which is, it's got nothing to do with duty because this decision was about suitability.
My lord, and indeed we did. There were arguments we made in both appeals. That was the argument we made, and it never came to be determined on the first appeal because ultimately,
Judge Saggerson said you don't have to deal with absolutely everything that could possibly be raised.
Indeed, my lord.
And is that the passage that you rely on in relation to this?
It is. So I think it's paragraph 33 to 37 of the judgment below, and I'd respectfully endorse everything that's said in that.
And that was the position you took on the first appeal that was settled.
On this particular issue, yes.
Yes.
So the first appeal was in effect settled because of the local authority considering it couldn't make good its case on suitability.
Yeah.
In the absence of its evidence to show compliance with the Article 3 criteria of the suitability order. I wasn't counsel on that appeal, but as I understand it, that's the position that was taken.
So the way in which was being put to the court this morning was that certainly the local authority, following that compromised appeal, would have been put on notice of what might be called the duty argument. But by the same token, the appellant was on notice of the local authority's stance, namely this was a review confined to the issue of suitability.
I'd agree with that summary, my lady, yes. And what has to be put into issue is the relevant decision under section 202. That's what has to be requested. There has to be a request for review of that decision. And the decision as defined by those gateways. Only those decisions can be the subject of a statutory review and appeal. And just going back to section 204 on page 30, subsection 3, which gives the court power to make orders on such appeals, says, on appeal, the court may make such order confirming, quashing, or varying the decision as it thinks fit. But again, it's the decision. So in this case, if I'm right, that there was the only decision that there was a request for a review of was suitability, then there's no power for the appeal court to say anything about duty or to quash any decision as to duty or vary any decision as to duty. Now that in my submission is a complete answer to the appeal, because if I'm right about that, then whether or not the reviewing officer or an officer at some earlier stage should have made and didn't a decision about the applicability of section 190 is just simply outside the scope of the review and the appeal to the court below and the appeal to this court in terms of granting a remedy of any kind. Now, just to make good that submission with reference to the authorities, I want to refer first to Ravichandran and specifically paragraph 35 at page 341.
That's tab 15.
My lady, yes. Now, I won't go through the facts of Ravichandran, but what was being argued about in that case was similar to the submission I've just made. So there was an argument about what decisions were within and without the section 202 review machinery. And just for the court's note, I won't go into it, but the arguments of the two competing parties are set out from at paragraph 28 and paragraph 29. And then at paragraph 30, the court gives its decision on that and finds a sort of middle way. It considers the position of both parties was misconceived. So that Mr. Arden's position for the local authority in that case was that there is an automatic ending of the main housing duty where the condition where an offer is refused. Because there doesn't need to be a decision after that. Any such decision that does come is irrelevant and not reviewable and not appealable. Mr. Latham, in opposition, said, no, the duty doesn't come to an end automatically. It can only come to an end where the local authority make a decision that it's come to an end, and that decision is reviewable. And the court at paragraph 30 said, you're both wrong. It does come to an end automatically, but where the local authority makes a subsequent confirmatory decision that the duty's come to an end, that decision is itself reviewable. And the facts of this case, as the court will see when which is sufficient to read the head note, but the facts of this case will see that what happened first is there was an offer, there was a request for a review of suitability. The local authority determined that the property was suitable and then said we brought our duty to an end. There was then a second request for a review as to the duty having come to an end. And another review decision produced. And so the substance of Ravichandran is about the interaction between those two reviews, which comes to the paragraph 35 of the judgment, which is where I started to refer your lordships, is what this court said was the right thing to do in those circumstances, and it puts forward a number of propositions. And starting at sub-paragraph 5, we're dealing with the main duty here and an offer to bring the main duty to an end, but the principles in my submission remain the same in terms of a suitability review versus a review on duty. The applicant is entitled to review of the suitability requirement, section 1937F, by virtue of 2021F of the 96 Act, and of the reasonableness requirement in section 1937F by virtue of section 2021B. It's possible and desirable for both requirements to be reviewed at the same time. The right to review both requirements and the intention to review both at the same time should be made clear to the applicant. The applicant is also entitled to a review of the decision of the authority as to the discharge of its duty by virtue of section 2021B. If the review takes place before the refusal of the final offer of accommodation, it will strictly be a review of the intention that the offer will, on refusal, result in cessation of the authority's duty. If the review takes place after the refusal of accommodation, it will be a review of the authority's confirmation that the duty has ceased by virtue of satisfaction of the statutory preconditions for such cessation. The applicant should be informed of the right to such review. It's desirable that such review decision of the authority as to the discharge of its duty takes place at the same time as the review of the suitability requirement and the reasonableness requirement. If it's intended that will take place at the same time, the applicant should be so informed. And the reason why the court goes to some pain to settle that out is it's saying, I think Mr. Arden's submission had been, it will be impossible to ever bring your duty to an end because you end up in a never-ending circle of reviews and new decisions that then give a fresh right to a review. And the court found he was wrong about that, rightly in my respectful submission. But really what I ask the court to take away from this authority is that there are distinct review pathways and that it is possible to make both requests for review or make a single request that asks for a review of both decisions and that they can be considered at the same time in the same decision letter, but that they remain distinct decisions and distinct reviews. So that's my first basis for saying the appeal is, in my respectful submission, misconceived, is that the court need go no further than say all that was ever requested was a review on suitability, and that's all that was required in terms of an ultimate decision. If I'm wrong about that, and the court is entitled to, and my learned friend is entitled to say, well, duty was an issue on the review, then I come back to the point I was making earlier about the sentence in both the minded to letters, both the review decisions, that says, in effect, I've thought, the council's thought about this and it doesn't owe you any other duty. Now, it can't be right in my submission that the appellant, represented throughout the review process by two sets of solicitors, doesn't take any issue with that on the review at all, is entitled then to go to the court and say, aha, that's not sufficient because it's not, it's unclear. And the final part of the review representations that my lady and my lordships weren't taken to was page 102 of the supplementary bundle. So this is the response to the second minded to letter in May 2023 after the settlement of the first county court appeal. Page 102, my lord. The header of the email is on the previous page, 101, right at the bottom. And it's from Anne Spowett, who's the solicitor acting for the appellant on this appeal. And she writes to Mr. Perdios, the reviewing officer, in response to his minded to letter and makes 3 points. All of which relate to suitability, yet again, solely. Entirely rightly, in my respectful submission, because that's the only review that was ongoing. Now, as I say, if I'm wrong about that, I say there was a Section 184 decision. It's the same decision that the reviewing officer says he's upholding. And it's the 24th of September 21 letter that the court's already been referred to at page 8 of the supplementary bundle. It's undated, but the parties have agreed it was sent on that date.
Can I just check the letter to which you took us at 102 in the supplementary bundle?
Yes.
Is that the last piece of correspondence before the 7th of June?
No. So if my lordship goes backwards, it's because it's the bottom of an email chain. There's a number of other points, but they all relate to suitability.
But none take away from the point you just made.
My lord, no. If anything, they bolster it in my respectful submission. Yes, so page 8 of the supplementary bundle, and the rubric in the penultimate paragraph of that letter that's repeated through the review decisions and the minded to letters is, I am therefore satisfied that the duty to help / provide you with accommodation has come to an end. Full stop. Now, in my submission, that is, as the reviewing officer explains in his minded to and review decision, that is the local authority saying we don't owe you any further duty. The duty to help, as in provide help and assistance, or secure any accommodation for you, has come to an end. That's because
under any Part 7 duty.
Yes, that's my submission. That's what that paragraph is saying, because that's what the reviewing officer finds that it says.
So that covers any duty to her as someone intentionally homeless,
Indeed.
or if they decide she's not intentionally homeless for whatever reason. And it is a statement that they're not going to provide any support, even if they could, through the route of her being an intentionally homeless person.
Yes, I mean you do end up in a slightly counterintuitive position as a result of section 193A, because you have someone who didn't become homeless intentionally, as it's accepted was the case, and as my lord pointed out in during my learned friend submissions, there was no suggestion that when she approached the local authority that the appellant had become homeless intentionally, because she'd been evicted as a result of the no fault section 21 procedure. So yes, we say that is the council saying, but sorry, I was saying you end up in the counterintuitive position that someone who did become homeless intentionally is owed the duty under section 190, but someone who, but for their refusal of this accommodation, would be owed the main housing duty is owed nothing at all. So the person who didn't become homeless intentionally is owed a lesser obligation than the person who did.
So you're offering us two alternatives. One is there was effectively no jurisdiction to be dealing with duty because the decision was solely as to suitability.
My lord, yes.
Two is, if that's wrong, then this counts as a section 184 decision. What do you say about the reasons?
Well, the reasons, I say, are shortly put, but then so were the reasons in Ahmed. In Ahmed, the reasons were you're not homeless anymore, and so we don't owe you a duty. Here it is, the relief duties come to an end. You've refused the offer of accommodation. The 193 duty doesn't apply. And yes, I suppose the officer could have gone on to say, well, section 190 doesn't apply because you're not homeless you've never been homeless intentionally. But that goes back to my point that it's not incumbent on the officers to say each and every duty and why they don't apply. There was no...
No, but he's obviously not saying the result of this is that you are unintentionally homeless, because that would be an acceptance of the main duty.
Yes, he's not...
Which didn't happen.
Well, it's precluded from happening by the Act. So the main duty can't arise under the Act. So the intentional homelessness would only be relevant if the local authority had reason or had satisfied itself that the appellant had become homeless intentionally. Now, I say become homeless intentionally in that context must mean the beginning of her current period of homelessness, which is where she's evicted from her previous private accommodation, not her homelessness
as a result of
having otherwise it defeats the statutory scheme otherwise, because it defeats the statutory scheme because the instance of homelessness that's being dealt with on the application is the homelessness that at the point at which the appellant applied to the local authority, and it's the only part of the requirements for the main duty or the 190 duty to arise that looks backwards in time. So it is homeless, is eligible for assistance, and became homeless intentionally. Now, on a reapplication, when you're dealing with a new instance of homelessness, a new set of facts, it's open to the local authority to say, well, the reason for your homelessness now is because you became homeless intentionally by not effectively engaging with the statutory scheme on your previous application. But it would be a stretch of the scheme in my submission for it to happen within the same application.
I'm now completely confused.
I'm sorry, my lord.
I'm completely confused. I thought that it's clear that when you refuse having been informed of the consequences, you refuse what is regarded as a suitable offer, two duties go.
Yes.
The main duty and the other one.
The relief duty.
The relief duty. But you're then in a state where you are homeless, and the reason why you're homeless is because you have not accepted the offer where the consequences have been pointed out to you. And I had thought, clearly mistakenly on your submission, that one of the effects of that, and it was really the premise I thought of much of Ms. Murray's submissions this morning, was that if you put yourself in that position by refusing a suitable offer, you are then at least liable to be treated as intentionally homeless. Do you say that's wrong? Because if you're not treated as intentionally homeless, what are you? You're nothing.
Well, you remain homeless. So for a start, so in the circumstances where you approach the local authority as homeless, you're in precarious interim accommodation for a brief period. You refuse an offer of suitable accommodation. Your homelessness continues. It hasn't stopped. And then I suppose that what the local authorities say here is, yeah. No, I see the point my lord's making.
Can't be right.
But there has to be, and as I concede in my skeleton, I concede that there has to be a decision as to what duty, if any, is owed after the operation of section 193A, which in itself would be a reviewable and appealable decision because it would be a decision as to duty. So I suppose if my lord's point, I don't need to go as far as rebutting my lord's point, because what I can say is whether this decision was right or not isn't the issue, because there's never been a challenge to it. There's never been, that goes to my first basis for saying the appeal should be dismissed. But in any event, the reviewing officer, if it was in play, to put it that way, on the review, the reviewing officer upholds it by saying there's no further duty owed, which must be taken to include section 190.
Okay, the main duty, which goes when she refuses the offer,
Yes. Well, it's
is the
prevented
duty
from
owed
arising.
to
Yes.
persons with priority need who are not homeless intentionally.
Yes, well,
She's undoubtedly in priority need. Does that mean she's treated as a person who's in priority need, who are not homeless intentionally, but she's not owed the duty that she should be owed under 193, or what?
well, she's
I thought, I have to say, at the moment, I can only make sense of this on the basis that if you knock out the main housing duty for a person such as this applicant, they are, under the scheme of things, treated as being intentionally homeless because they're not going to be treated as unintentionally homeless. And that's the whole basis of Ms. Murray's submissions this morning, which is there is this residual duty or potential duty
yes.
where a decision's got to be made.
Yes, and I accept that that's right. So I accept that the operation of section 193 on its own does not bring the entire housing application to an end.
The loss of section 193 cover duty.
Yes, the prevention of it
Nothing to
arising.
it.
Yes, I accept that doesn't determine the whole application, because I accept there are situations where someone might be found to be intentionally homeless after such a refusal that triggers the operation of section 193A. And that,
Hold on, I have to look at it.
but yes, I say that there is such a decision that's upheld on the review, and no reasons are ever put to the reviewing officer that he's wrong about that. So the reviewing officer, as I say, so the original decision on page 9, which is the 24th of September 21 letter, I say fulfills the requirements of section 184 because it says we don't owe you any further duty, gives reasons, and the reviewing officer in in his minded two letters over the page on page 11, 2 pages over on page 11. That's an example of the wording that appears several times. I must therefore uphold the council's decision given in the decision letter of 24th September 21. The council does not have any further duty towards you.
So the council's position is that as a result of this process, she is not owed any other duty by the council.
My lord, on this application, yes, that's
And
our position.
therefore we needn't concern ourselves whether, as a matter of fact, the council did provide support or not, as to which at the moment I'm unclear.
My lord, that's right, because if duty was in play on the review, then what had to be then for the review to be vitiated, there would have to be an error of law. Now, saying it was never put to the a reviewing officer is entitled to take as a starting point the matters that are raised to him on review. So it is unsurprising that he deals with this point very shortly in the review.
Because the point was a narrow one, and when you used the phrase on this application, you were talking about an application for a review on the sole issue of suitability.
My lady, yes. So it cuts across both my my responses to the appeal. But even putting aside, if my learned friend is right, that somehow the local the reviewing officer had jurisdiction to either to review the decision, the earlier decision on duty. So to say either I uphold it or I vary it or I quash it or whatever the reviewing officer can do. I reach a different decision for the following reasons. What he says is I uphold it, and the nature of the decision was that we don't have any further duty towards you. Now, if he's entitled to deal with it that shortly in the absence of anything being said to him that takes issue with it in my submission. And it's unfair on an appeal to then criticise him for not dealing with it in more detail or
When you
provide
haven't
further
raised
reasons. Beg your pardon, my
When
lord.
you haven't raised it as a decision to be reviewed.
Yes, well, you haven't raised this as a decision to be reviewed, but then even if it's as I think my learned friend submissions, it's implicitly required to be reviewed, you still have to put your case forward as to why you say the original decision was wrong. And he couldn't have been clearer in what his view was throughout the review process. That the exception to that is the letter that my learned friend took the court to about accommodation pending appeal, because that's the only time where, in something of an aberration in my respectful submission, that the reviewing officer talks about intentional homelessness and the review decision having determined her to be intentionally homeless. But that letter needs to be put in its context because it's outside of the review process. It's part of the process running up to the appeal. It itself wasn't appealed because there's a separate right to appeal a refusal to accommodate pending review under section 204A. And so really it's irrelevant to the review process and the representations that were made on review. Because what he says in that letter doesn't make a huge amount of sense, because what it says is, in my review decision, which the court's looked at, I found you were intentionally homeless, and he doesn't find that at all in the review. Doesn't use the words. So it's at page 27 onwards. And one can see from the heading, so it's a response to a request for interim accommodation pending proposed 204 appeal, 204A Housing Act 1996, which gives the local authority a discretion to accommodate pending appeal, and also creates a separate right to appeal a decision refusing to exercise that discretion.
And this is before the first appeal to the County Court.
My lord, yes. And so the first review decision has been made by this point. And he talks about his review decision in this letter and finding a few times that which found your client was intentionally homeless was correct. Now he doesn't find that in the review decision, so I don't know whether this is I'm speculating, but I don't know whether this is a sort of there's a cut and paste error going on here from some other decision. I don't know, but it can't be right that because the original review decision that's at page 17 doesn't find, as this letter says it does, that the appellant's intentionally homeless. But it's limited to that one issue, that decision. It's limited to about the discretion to provide accommodation pending appeal. No challenge is ever made to it. And he does still, in any event, in that decision, on page 28 of paragraph A, the final sentence of that paragraph is, once I concluded the offer was suitable, this meant the local authority owed no further duty to your client. So he's still saying there's no further duty.
I mean, it all begins with section 202, doesn't it? Because what that does is provide clearly identified gateways to reviewing and requesting a review of a decision. You've got the identified gateways, and then picking up any right of appeal flowing from it. That at section 204 then refers back to 202, picking up 202 and the request review under that section.
My lady, yes, that's my
I know that's your first point.
my first point. And there's no escaping it in my respectful submission. As unsatisfactory in some ways as that can be, if the court thinks there might be some error in some other part of the decision making, but it is within those tram lines, if I put it that way, that the court and the reviewing officer have to operate. Because if that wasn't the case, one can see how if there's some mistake that goes unnoticed or is uncontroversial early on in the process, that then is picked up once the chain of decisions has moved on, as it had in this case, it does create this difficulty of not being able ever to kind of escape the cycle of challenge and review.
Which is referred to in the guidance as something that's undesirable, or Miss Mario said it was something that's undesirable. You go round and round in circles.
My lord, yes.
The okay.
My lords, I wanted to take the court briefly to Ahmed, my learned friend, in her skeleton and in all submissions referred to Ahmed. I just want to be clear about the facts of that case. If the court could start on page 423 of the authorities bundle. So paragraph 9 of Lord Justice Newry's judgment. It's clear here that what was reviewed was a decision on duty. And that's the nature of the review that was requested. Because I think what was suggested in my own friend's skeleton was that there should be a first instance decision or a sort of a section 184 decision for the first time in the review decision. Now that's not what the facts of Ahmed were. In Ahmed, there had been an earlier decision of the 14th of December 2021 that the relief duty had come to an end. And that the officer further said that under section 1843 of the Act, she was notifying Miss Ahmed that the main duty does not apply as you are not homeless. That's the original decision that was then reviewed in Ahmed, again by Mr. Perdios, so by the same reviewing officer as in this case. And so then when, to move forward to paragraph 38 of the judgment on page 430, where Lord Justice Newey sets out the issues for the appeal. In her letter to Miss Armid of the 14th of December, the officer said that she was both satisfied that the room 7 was suitable accommodation and that it was reasonable for her to continue to occupy it. On that basis, the officer considered the council's relief duty come to an end further that Miss Ahmed was not homeless and so could not be owed the main housing duty under section 193 of the Act. Mr. Perdios endorsed these views in the decision letter. So the decision letter is the review. The original decision is the letter of the 14th of December. And so what Lord Justice Newey then says when he's determining the homelessness point right at the end of the judgment in the passage that's lined and that my learned friend took the court to, paragraph 62 on page 437, is the court is not dealing with a first instance section 184 decision in Mr. Perdios's letter. It's dealing with his treatment of it on review, where there had been a request for a review of the original decision. But my lords, I think because there's quite little between us on the law. I suppose on remedy, the other point I make in my skeleton is, so if I'm wrong about all of that, then the most that the appellant would have been entitled to would have been, at the height of my learned friend's case, would have been a decision that in fact she was at that stage owed a duty under section 190, the short-term accommodation duty. And there's a case in the bundle from the Administrative Court at tab 13. It's on the application of Nipio and Croydon, and the court needn't go beyond the head note. But the effect in that case was that the challenges were found, because so much time had passed during the progression of the judicial review, that it had become academic, because there had been 3 months' worth of accommodation. And so on any view, there had been a reasonable period given to find accommodation of her own, and that's all the appellant would have been entitled to, and she must have had that in my submission during the course of the review from September. Because of course there's the decision in September that says we don't owe you any other duty. And I'll just take it from my learned friend skeleton when the eviction in fact happens. But it's some significant time later. So I say any, and again, there was a point that was made below, is that any relief would have been, there would have been no point substituting a decision saying that the 190 duty is owed, because she'd already in effect had the benefit of it, because she was in accommodation for a period after, for a reasonable period of time that should have given her the ability to find accommodation of her own.
And the period you rely upon is the period from original decision,
yes, the
to the
24th
end
of September.
the review period.
Yes, the end. So 24th of September, 21.
suggesting
my learned friends
February
concern.
22.
17th of February 2022, she was evicted, following the decision which was the 20th of January.
Yeah, so a little less than 4 months. But over 3 months, isn't that? From 21st of 24th of September to October, November, December, January, February, yes.
What's the remedy? Is there a financial remedy?
Certainly not under...
If the end of whatever process was, that instead of being given to the 17th of February, she should have been given to the 17th of March, April, May. What would now be the effective remedy?
Well, in my submission, certainly on this appeal, there can be no effective remedy because the only remedy the court can make on this appeal is to vary quash confirm the review decision.
Okay, but we're assuming we've got as far as saying the review decision is, or the reviewed decision is no short-term duty, but she's had 4 months or just under 4 months in accommodation. And let us say that, so the best outcome would be, let us say, she should have had 6 months. Let's just take an arbitrary figure.
My lord, yes.
What is the practical benefit to her of someone saying in 2025, you should have had another 2 months? Is it financial? Is there a financial remedy approach? Not that I'm aware of.
No, my lord, no. I'm not sure there would be.
Having a piece of paper, which would, I'm sure, be extremely satisfying for her, to have a piece of paper from the Court of Appeal saying she should have been given more support. What's the point?
Well, on my case, there isn't one. What my learned friend would say is that the whole decision goes, the whole decision is quashed, because what this is really about is reopening the can on suitability again. Because what my learned friend says is the decision is quashed. We can make a whole load of new submissions to you about suitability, or the same submissions again, as I think my learned friend candidly puts it, that a different local, different officer might make a different decision. In my respectful submission, the chances of that are quite slim, given the pattern we've seen. But
But also the boys are 3 years older.
My lord, yes.
So there could be differences if the decision's retaken now.
No, because the offer was refused, one looks at suitability at the time of the offer rather than at the current time. So,
I mean, I'm all for giving real remedies to people who have been deprived of things that were their rights, but at the moment, with the greatest respect to the appellant, I'm wondering what benefit these proceedings can have, apart from your suggestion that it could lead to opening up the whole question of suitability again.
Well, that I think is that if my learned friend's right, that is a potential benefit.
Can that be superseded in the new application?
Well, it depends the degree to which my learned friend's case is right. Because if my learned friend is right that there's never been a Section 184 decision, and we have to make one, we will have to form a view about whether she's in her current circumstances homeless, eligible, and in priority need. I'm told that we're satisfied of all three of those already on the new application. And then we will have to form a view of whether she became homeless intentionally. Whether there is a material, without going back on the ground that I've been over with my lord, whether there is a material distinction between that being on the old application or the new application is a point I wouldn't like to occupy the court with anymore. But yes, so the decision will have to be made on the current circumstances as to the duty that's owed. But I was exploring this briefly with my learned friend over lunch, very, very briefly over lunch, but I wonder whether there's in fact a prejudice to the appellant in it going under the old application. Because if the old application persists, then the the prohibition on the main duty arising still bites. Whereas on a new application, although that is going to factor into a determination on intentional homelessness, there isn't the sort of prohibition at the moment on the 193 duty arising under that new application. Because if the appellant's right in what she says in her representations on the new application, that she had a period of settled accommodation that broke the chain of homelessness, that she's in effect got a new instance of homelessness and a new application.
And that would supersede the original decision, or could lead to the original decision being superseded. Because as things stand at the moment, the Section 193 duty is not owed.
It can't be owed on the old application.
Quite.
The new but as things stands, the decision of the judge below remains true. The review decision was confirmed. The local authority there's nothing that prevents the local authority. There's nothing to challenge the local authority's decision from September 21 that it didn't owe any further duty beyond that point. And so if all of that's right, then there was a new application in October 2024, a new acceptance of the relief duty, and the local authority offered interim accommodation that was declined, and it will now make a decision about what, if any, duty it owes. But that decision won't be subject to Section 193A, I think that's right to say, because it's a new instance of homelessness and a new application. But yes, I've probably made things incredible. I hope I've not made things too much murkier than before I stood up, my lord. But
well, we know what the present position is, and
yes.
Events have moved on.
My lady, yes. And I suppose if the court is with me on what I say about the machinery of Section 202 and 204 and the need for a specific request, or at least a request that is unspecific, so that the thing about this case is the request that comes in is very specific. It is not just a request from a layperson that says, I'd like a review of this decision in its entirety. It says very specifically, I am reviewing the suitability under this gateway.
Yeah.
And if the court's with me on that, then it needn't trouble itself with any of the other matters, and they can be saved for a case where they're determinative. But it's unless I can assist any further, my lord, my ladies.
Thank you very much indeed, Mr. Mullin. Miss Murray.
Thank you, my lady, my lords. Firstly, I'm not instructed on the new application. I can't confirm what my learned friend has said about the status of the current submissions. It was said, I think, by my learned friend that my learned friend's submissions on the new review. I haven't made any such submissions. I'm not involved. It's improper for him to give evidence from the bar on appeal about the current status of the relationship between my lay client and his instructing solicitor when I can't comment on it. The documents aren't before the court. We can't confirm the position. It shouldn't affect the way that your lordship deals with the appeal.
I'm a lady.
My lady as well. I do apologise. From the little that I have been able to glean from my instructing solicitor over lunchtime is that a highly unusual extra statutory letter has been written to my lay client saying that she was intentionally homeless, but it appears to be suggesting that she was intentionally homeless from Wren Court, which was prior to any of the application that we're now dealing with. Well, the status of that letter is very unclear. From what little I've read of it, the reasoning seems to be confused. I invite the court to disregard all of it. There's been no application formally made by the respondent to say that this appeal is academic or should be treated as academic. The focus that this tribunal should have is about whether there is an error of law in this decision which, on my case, vitiates it entirely, or my learned friend seems to be conceding that certainly there ought to have been a decision about what duty was made beyond just the section 193 capital A disapplying the main housing duty. He seems to concede that much, but wants to invite the court to find that what there was said about duty was sufficient for the test in Ahmed.
Well, I'm not sure he concedes it. His primary position is
that it wasn't an issue.
Yeah.
Well, I'll address both of those just by reference very briefly to the authorities. The first point that I'll deal with is as to what's an issue. I took your lordships, my lady, very briefly to tab 16, which is the case of Temmoor and Hackney. In the judgment of Lord Justice Lewison, which begins at paragraph 74 of the report, which is 355 of the bundle, Lord Justice Lewison addresses himself to an extremely similar question. I invite my lord, my lady, to read from paragraph 74 onwards down into paragraph 77.
But this deals, does it not, with an original decision rather than the review?
And it goes on to make the point, yes, which Lord Justice Lewison makes good in the subsequent paragraph 78 and over the page, that the decision on review is itself a decision. It is a free decision. It must take into account everything, and it must take into account everything as at the date of review. And I opened my submissions this morning by making the submission that were you as an applicant to say to the local authority, I don't want you to consider this particular aspect of my application, you would have no right to do that. The local authority must reconsider everything, and that's why we have decisions such as Robinson or indeed Temmoor, and indeed in Ravichandran. The factual circumstances had changed by the date of review. So at the date of review, everything must be reconsidered. And in these paragraphs here, Lord Justice Lewison is saying that the statutory language is very much in the present tense. The review decision is a decision that is freestanding. Now, in that light, so for instance, in paragraph 81, first, the outcome of the review is itself a decision. And then my lord goes on to consider on page 356 and over the next page, the argument for limiting what should be considered on review. And he concludes at the end of paragraph 84, for instance, I can see no warrant for limiting the issues referred to in that regulation to those which the applicant has chosen to raise. And then at 85, the emphasis is on the present tense.
Where are you?
Paragraph 85, sorry, because that's page 357. I'm just following through the judgment of Lord Justice Lewison. And he concludes at the end of 85, if after the original decision but before the review the applicant ceases to be homeless, it would be extraordinary if the authority still had a duty which in terms is confined to those who are homeless or threatened with homelessness. So the point being that the matter just has to be reconsidered at the date of review. That's its purpose. Seen in that light, the sub-paragraphs of section 2021, which are, we've been referring to them today as the gateways for requesting a review, those are indeed opportunities to request a review. It's true, but their purpose is, in practical terms, to avoid the use of the High Court. Those letters describe the sorts of appeals under section 204 which will eventually be heard in the county court. Their legislative function, as it were, is to protect the High Court from being the destination for the hearing of section 204 appeals. It's not that those letters under section 2021 are designed to limit the way in which an applicant can put their case to the local authority. They're not designed to stop an applicant from raising a certain thing, or to create a bar for the local authority to say, well, you didn't ask us to review it in those terms, therefore we're only going to focus on X or Y. That's not their purpose. Their whole reason for listing those ways in which a decision can be appealed, is to provide a subsequent jurisdiction under section 204 for the appeal process to be in the county court rather than in the High Court. Historically, that was the reason for those provisions to be introduced, and indeed is the reason why the county court is the site of a judicial review in the county court, as it's referred to, because historically these appeals were heard in the High Court and they were too many in number, and so the jurisdiction was transferred to the county court. It looked at in terms of what this statute is for. It is for homeless applicants to review and ultimately appeal decisions about their rights. So to understand those letters under section 2021 as limiting or indeed placing some technical barrier to them raising arguments or having matters considered would be contradictory to would seem to be at odds with the purpose of the homeless legislation. And indeed, for instance, I took the court to them already, so I won't go to them again. But for the court's note, I took the court to the case of Begum, which is cited as a case for which as authority for the proposition that a section 204 appeal is a judicial review in the county court, and the whole range of issues, a whole range of public law arguments can be raised. It's not just those limited in any way. They've got to be areas of law, but they're not limited in any way. And also in the case of Begum at 467, I gave the court the paragraph reference before. The court emphasises that there is a public interest in the section 184 decision.
So, your submission, I think Mr. Mullin would accept that where a request for a review is made under any of the paragraphs, all matters that are relevant to that requested review, specified review, can be taken into account. That seems to be clear. But what you're proposing is that any review request for a review, however specific or unspecific, not only opens up every single potential ground of review, specified or unspecified, but places the onus on the authority to identify the points of dispute that might be raised. Is that right? Sounds a bit of a stretch to me.
That's not, respectfully, that's not quite what I mean, my lord. So,
Tell me
in
what it is.
in Temor, Lord Justice Lewison is saying at the review point, that is an opportunity to review the decision, and it must be a review. And so in that sense, that is, I am inviting the court to find that the reviewer is not limited to the jurisdiction specified by the solicitor or indeed the litigant in person, as will often be the case in practical terms, of the review request originally made. And that's exactly what Lord Justice Lewison says. However, I think what my lord would assist is there is obviously a distinction between an inquiries point, which is the sort of authorities such as Cramp and Hastings. So in those cases, and I think in an inquiries case, it would be a legitimate criticism which the local authority could raise of the applicant to say, well, you didn't bring to the local authority's attention a certain factual matrix, so our inquiries didn't investigate that avenue. And that indeed has been, that's been the subject of several authorities. But that's very different to the local authority failing to consider what, if any, duty is owed, because that's a statutory obligation which Parliament has entrusted to the local authority, and it is a jurisdiction which the local authority must exercise regardless of what is asked of them, in my submission. And similarly, it's not as though that's fanciful, as in Temor, when Lord Justice Lewison reasons that it may well be the case that by the time the review is undertaken, an applicant is no longer homeless. Well, the authority should be able to say at that point, the factual matrix is different. We've considered whether we owe you any duties, and we don't, because you're no longer homeless, notwithstanding our previous decision making, and notwithstanding that the applicant would be very unlikely to have said, please review what duty is owed in that scenario. So it isn't practical. It wouldn't be sympathetic to the meaning of the statute to understand those letters under section 2021 as limiting the review in any way. The applicant and the local authority aren't on an equal footing. The local authority is charged with an obligation to make a decision on somebody's homeless application. And whilst Cramp and Hastings type points are valid, the applicant must bring to the local authority any factual matters which they require an investigation into. The same simply can't be true of the legal rights, the legal obligations on the local authority, because apart from anything, there's the practical issue of the fact that many applicants will be in person, and it would be very unfair to impose upon them a requirement that they look up section 2021 and determine which of those subsections to request a review under, and if they got it wrong, they would be limited to a review on that topic. And in fact, in Ravi Chandran, which is a case that I took, I won't be very much longer, which is a case that I took the court to this morning, the burden is on the local authority, paragraph 35 of that authority, the burden is on the local authority to make clear to the applicant what their review is going to be about. If it's going to be about suitability and duty at the same time, the local authority has to make that clear. If there's going to be a right of review arising from one or the other or the both, the local authority needs to make that clear to the applicant. One final extremely brief point. My learned friend referred to Ahmed and said, without taking your lordships to the paragraph, that the paragraph which was approved by Lord Justice Newey in that case, which is at 62, paragraph 62, was very, very brief. But it's true that it was very, very brief, and I took your lordships, my lady, to it, which it's at paragraph 20 of this report. It's a subheading and only 4 lines. However, what it does, which is crucial, I say, is included a reference back to the previous parts of the decision letter. So albeit it is brief in itself, its structure is clear. It's clear to the reader that the reviewer knew what they were doing. They knew they were required to review, for the purposes of section 184, what, if any, duty was owed. They knew they needed to make a 183 decision, and they were making it. And yes, they're referring back to the previous parts of the decision, but that's the practical reality of writing a decision letter that contains several decisions in one letter. And I wouldn't, it would be illegitimate to object to that. However, it shouldn't be dismissed. Although it's only 4 lines and 1 subheading, it does engage with the substance of the obligation of the local authority. The decision-making jurisdiction that they have. Unless I can assist further, those are my submissions.
No, thank you very much indeed, Ms. Murray. You will be unsurprised to learn that we're going to reserve our decision. We are very grateful to you both and those who worked with you because each of you has provided considerable assistance to the court. When the judgment or judgments are in draft, they will be sent to the parties. You will have sent to the court the names of the individuals to whom any drafts can be sent. As both of you well know, they will be embargoed, and you know the consequences of any breach of embargo as set out in the Counsel General for Wales's decision. We will invite responses based only on typographical errors, and in respect of any consequential orders, we would urge you both please, together with those who instruct you, to reach an agreed order. If it cannot be made, the court will accept written submissions and everything will be handed down electronically. But for the moment, our thanks to you both for what was a very interesting case. We do not underestimate how much it will mean to the appellant, but we are grateful for all you've done.
You're welcome.
Did you eat something there?